And welcome to the Week 7 video lecture. In Week 7, we're going to talk about lay and expert witnesses. We have two different kinds of witnesses. They come in two different flavors. First is the lay witness, and the next is the expert witness, as you would expect. And we're going to decide what those two things are because they are different. Although a person who would normally be an expert, such as a doctor, can also testify as a lay expert, depending upon how they are testifying and what they're testifying to, as we will see. And a person who you might think just be a lay person and may not have any particular expertise, may actually have an expertise in a certain area and might actually be able to testify as an expert without anything more than qualifying their qualifications, as we'll see here in a minute. So what's important is, as to a lay witness, the only foundation that you have to lay for a lay witness is the fact that they have personal knowledge of what they testify to, that they heard and they saw what they are going to testify to. That's it. They're just simply people who are testifying to what they heard and they saw. Expert witnesses, though, are different. They have to have certain expertise in a particular area. That doesn't mean they have to be a doctor or a scientist or an engineer, for instance. They can be people who just have very good practical experience in a certain area, such as a good quality construction contractor, for instance, might be very good as an expert on defects in housing. They may know exactly why this house is defective, why it doesn't meet up to code, why, because they do that every day and they know that stuff very well, and so they can end up being an expert. So when we have an expert, we have to lay a foundation for the expert. We cannot just say, okay, well, this guy's an expert, so let's hear what you have to say. No, you actually have to lay a foundation, which means you have to put on evidence that establishes the fact that the person is an expert in the field and that expert testimony will help the jury in the area that it's being offered, as we'll see here in a minute. All right, we can also use lay testimony in lieu of expert testimony in certain situations, as we will see. All right, also, the basis of the opinion of opinion testimony by experts, we're going to look at that, and also refreshing the expert's recollection. We have an expert. They give us an opinion. That's why we bring them in as an expert. Let me give you a good example. We have a motor vehicle accident, and no one can exactly tell what happened. Maybe the two people involved, maybe one of them is dead, and the other one cannot remember what happened. And so we would bring in an accident reconstruction expert to reconstruct the accident from the evidence that was collected. And they can often do that reasonably well, actually, surprisingly well if you've ever used them before. And then we have to ask them an opinion. In your opinion, who was the cause of the accident? And they will say, well, it's the car that was going northbound that was the cause of the accident. Okay, and then please tell us the reasons or the basis for your opinion. You just can't say, oh, I got an opinion that such and such had the cause of the accident. It has to have reasons. If it doesn't have reasons, it's not going to be accepted as an expert opinion. Also, sometimes we get into trouble when the opinion is as to the ultimate issue. Sometimes, and we'll see how that is. For instance, you might have a negligence case, and one of the experts may have an opinion as to whether a doctor, for instance, was negligent in whatever procedure that they had with the patient, and that's the ultimate issue in the case as to whether they were negligent. And so the opinion is actually going to sometimes be allowed to deal with the ultimate issue itself. In essence, as if they are sort of putting their opinion out there for the jury that the person should be found guilty of negligence, and it's not just on some sub issue in the case. It's the ultimate issue. So we'll see that becomes a problem. And also we'll see what's all about when we talk about court-appointed experts. There are times when they don't want the parties to be battling experts because courts also know that experts are sometimes called hired guns, and they, you go out and you hunt for experts who can give you the opinion that you want, rather than actually going to a single expert and saying, what do you think of this case? And maybe sometimes getting some bad news that's not going to go your way. And so the judge will sometimes say, you know what, I'm not going to have you people spending all this money on these experts, both of whom are hired guns, and no one's going to know whether they're really anything other than unbiased experts. So we're going to have a court-appointed expert actually go in and examine the situation. This is also very, very commonly done in family law matters, where there is extremely biased experts on both sides, and it just, the court doesn't want to see it because it's a waste of their time, and they want to see some unbiased experts in that area. Maybe it's just too important as to who gets custody of the kids, for instance. All right, let's look at opinions and inferences. We're going to know what those definitions are. An opinion is a belief based on, in part, on impression and in part on direct knowledge, meaning you come to an opinion about something because you come to a belief after you've seen stuff out there about the thing you're rendering an opinion on. You may have an opinion, for instance, as to who was the cause of an accident if you happen to have been out there and watched it, or even if you had read the report where evidence about what had happened and witness statements were all put together and so on. You may have an opinion as to whose fault it was in the accident, for instance. That's what you might do just ordinarily, and also experts do the same. Although experts usually have to have some really good reasons that will bring out their expertise, something that the jury would not have, and something that the jury would have to benefit from before we use them. Also, an inference. An inference is a conclusion derived from implied as well as direct information. So, for instance, we often infer lots of different stuff. The old saying, where there is smoke, there is fire, is an inference. It says, where you see smoke, well, there's going to be a fire there somewhere. Well, that's a conclusion from direct information. It's implied from the direct information, derived from the direct information. Essentially, it's a logical leap that we can make because it's basically a generalization. We know when there's smoke, there's going to be a fire, typically. And so we'd be looking for a fire somewhere. Now, by the way, not every single time that you see smoke is there actually a fire. But since it happens so often, we can make a logical inference that it is probably a fire. Maybe very highly probable it is a fire rather than something else. But remember that we use inferences all the time. Every circumstantial evidence case that's ever been out there uses inferences. So, for instance, we may be able to line up a whole bunch of evidence, all of which points to the defendant's guilt. No one of which is conclusive by any means, but all of them together have lots of force behind them. And each one is based on that inference. We are saying, okay, because these 5 things are all true, and it's so highly unlikely that the person is not guilty if all those 5 things are true, that's why we can infer that that person is guilty in the case. Okay, let's look at lay opinion. Now, we'll leave expert opinion here away for right now. Let's just look at lay opinion. A lay witness, again, is just somebody who comes in and testifies to what they heard and they saw, with no expertise involved, no expertise necessary. Just what did you hear? What did you see? And that's the very typical witness. We call them lay witnesses because they don't have any particular expertise that makes their testimony any different. And again, you can have a medical doctor, you can have an engineer testify as a lay witness because they simply heard or saw something, and it doesn't make any difference whether they have any particular expertise as to what they're going to testify to. However, normally speaking, lay people cannot testify to their opinion. Their opinions have nothing to do and have no relevance to the jury whatsoever. For instance, if a lay witness came in and said, well, I only saw half the accident, but I think the plaintiff was at fault here. We don't really care. No, that's the province of the jury to decide who is negligent and who is not for some lay witness to do. And so we don't allow lay witnesses typically to have an opinion, at least testify to an opinion. They may have an opinion, but they don't testify to it. And so what we do is we do allow it in certain cases because that opinion it has value, as we'll see here in a minute. So a lay opinion is an opinion of an ordinary person applying no particular expertise in offering the testimony. It's allowed under only certain circumstances. All right, so opinion of a lay witness is limited to only these circumstances. You'll see when you look at the circumstances why we allow it. If it's something that is rationally based on the perception of the witness, such as when you looked at that person who was 100 feet away, did it look like a male or female? Was it an adult or a child? Well, that's actually an opinion because they weren't close enough to be sure as to whether it was a male or female. And by the way, even if they were close enough, people have been fooled by men dressing up as women, women dressing up as men. They actually have been fooled as to what the actual gender is of the person that they're seeing. So even when they say, oh yeah, that was a male or female, they're actually testifying to an opinion. So long as it's rationally based on the perception of the witness, it's things that we know that witnesses can do based on their impressions from what they can see, then we allow it. It also has to be something that's helpful to a clear understanding of the witness testimony or the determination of a particular fact in issue, and cannot be based on any scientific, technical, or other specialized knowledge. All you have to do in terms of a lay witness, again, is you have to simply lay a foundation that they have personal knowledge of all of these different things in order to allow lay opinion evidence. So, for instance, if you had a question, was it a male or was it a female? Was it an adult? Was it a child? The first thing you'd have to do is, did you see them well enough that, no, actually, if you start out with, can you normally, when you go down the street, tell whether someone is a male or female? Yes. Can you tell whether or not they are an adult or a child? Yes. Okay. Now, of course, it has to be that the gender of the person saw will have to be important to the case, of course. And then once you've done that, and did you see this person is the next thing, which is your foundation of personal knowledge. Yes, I did. How far away were you? I was about 100 feet away. Okay. Could you tell for sure whether it was a male or female? Not absolutely for sure, no. Okay, well, what was your opinion as to whether they were a male or female? Oh, I thought it was a female. Okay. And then tell me, what reasons did you have for why you had that opinion? And then they'll tell you. Now, that's allowed because, again, it's rationally based on the perception of the witness. It's helpful to the clear understanding of the witness's testimony or determination of a factual issue. It's not based on scientific, technical, or other specialized knowledge. So they can testify to what is, in fact, an opinion, and it's based on it's rationally based on their perception. So, for instance, whether a person is drunk is something that we can allow them to testify to. So, here are some examples. Another person's identity, age, gender, and competency. Competency is an interesting one. Let's assume that we are going to a hospital and we're talking to one of the people in the hospital. Looks like they're very, very sick, very old, and we've been talking to them, let's say, for a week because maybe we're in the hospital also, but we just happen to visit them on a pretty regular basis every day. Well, when you talk to someone, you get a pretty good idea whether they are mentally competent or not. That means that whether they have all their faculties or not, or whether something's missing. If they're not running on all thrusters, so to speak, then maybe they're not competent. We know that. We know that as people. We see that all the time. Whenever we look at people and talk to them, we can usually tell. It takes a little while sometimes, but then all of a sudden they'll say something that makes it real clear that perhaps they don't have quite enough competency, or at least it's been compromised to some extent. Well, they can talk about that. Lay witnesses can have an opinion as to a person's competency. The question is, did you see that person long enough that you would be able to judge their competency? Yes. Have you judged competency of other people in the past? Yes, I have. Okay. Now, what did you judge this person's competency to be? I thought the person was incompetent. Okay. What were your reasons for why you thought the person was incompetent? And they'll tell you what the reasons are. And that's how it goes. Now, again, it's all opinion. It's not based on any scientific knowledge. That if someone says, "Well, I had a degree in psychology, and so I tell you they're incompetent." No. You have to qualify them as an expert witness in order to have them testify that way, because a lay opinion witness is one that is not using any scientific knowledge of any kind. Okay. Another person's sanity is another one. We know people can do that. We know that if you get close enough to someone, you talk to them enough, or be around them enough, you're going to be able to judge their sanity. Their demeanor, their mood, or their intent can also be something. For instance, you may see someone walking down the street, hot mad, stomping on the ground every time they move, and having this very intent and mean look on their face. Well, you could say at that point this person first was angry. They had some intent. They were very intent on moving in the direction that they were moving with great energy. and their demeanor was they were mad, they were angry, they were upset, that kind of thing. Happens all the time. We see this every time we look at somebody. We can tell what their demeanor is, what their mood is, and sometimes their intent, depending upon how they're acting. Also, intoxication or sobriety. And by the way, just because someone says it looked like he was drunk when he's walking down the street, well, it may have been that he had cerebral palsy, for instance, actually. So his opinion is actually wrong, but that doesn't mean he can't testify to that opinion. He looked like he was drunk to me. That doesn't mean that the jury's going to assume that he was drunk. The jury's going to say he looked like he was drunk, but we don't know whether he was drunk or not. We only know that he looked like he was. So it could be other things than being drunk. But at least it lets us know more about what the witness was seeing, because we know what a drunk looks like when they're drunk and walking down the street. They're stumbling, they're kind of moving back and forth as they're walking, and all that kind of stuff. Also, ownership. Interestingly, if you own a piece of property, you may have an opinion as to its value, and that's because we just know that people who have property often go out and compare prices to what it is that the property is worth. This happens very frequently, especially for houses. People are trading houses not too infrequently, and they get a pretty good idea of what the value of the property is, because they will, a neighbor sells their house. Oh, and you go over and ask your neighbor, how much did you sell your house for? Oh, that's interesting. How many more square feet do you have than mine? And now you get this idea of approximately what your property is worth. Happens all the time. So we know that someone can actually testify to that, even though they're a lay witness and they're not an expert. It may have otherwise taken an expert on fair market value of property to testify to that, but no, if you own the property, then you can testify to the opinion of its value. Also, the state of health, sickness, or injury. You can tell whether someone looks like they're sick or whether they look like they're perfectly healthy, or whether maybe they're walking with an injury of some sort or another. Maybe they're walking with a bit of a limp, something of that sort. Speed, distance, and size. Also, that's an opinion, because unless you measured the distance, unless you actually had a scientific instrument to tell you exactly what the speed is, or you went out and measured the size, you don't actually know what those things are as a lay witness. And so it's actually an opinion based on your ability to judge speed, distance, and size, but we know people can do it within reasonable accuracy. And so what a person's impressions of the speed, distance, or size is important information. It could be good information for the jury to know. Also, the degrees of light or darkness. How dark was it that night? Or how dark was it that day, if it was maybe a big thunderstorm that was coming in, something of that sort. How much light was there out there? Well, I could see without any obstructions whatsoever for a quarter of a mile. Okay, that tells us approximately what kind of light there may have been out there. All right, the value of the witness's own property, of course, that we just talked about that. Also, ownership of the property itself can also be testified to as who owns property. Okay, that's lay opinion. We can have lay opinion, but otherwise, a lay witness is simply testifying to what they heard and they saw, and only based on what is their personal knowledge, and that's it. But now we get into expert opinion. That's a different matter. It's a different qualification. And just to give you an example of what this all means is I've had doctors who have testified as experts, as you might imagine, in cases where people got hurt. But I've also had doctors testify as lay witnesses, even though they were, treating somebody in a hospital. I bring them in. By the way, they hate this because they don't get paid as an expert, but that's okay. I bring them in and I say, I don't care what your diagnosis was. I don't care what you saw. Did you meet this guy named John Jones on this night of such and such in the emergency room? Yes, he came in. And did you treat him? Yes, I did. Okay, well, when you were treating him, did he say anything to you? And they'll say, oh, yeah, he told me that he killed somebody with a gun. Okay, thank you very much. Well, now, all I'm using that doctor for is as a lay witness what he heard or saw. Has nothing to do with his expertise. People, hear things all the time without having to be experts. And so he doesn't get paid his expert witness fee. He comes in for a $35 witness fee, and that's it. And he doesn't get his $2,500 per hour that he would normally get as an expert. That, on the other hand, I may also have somebody who is, a contractor who's been in the business for 5 years, who builds houses, to come in and testify as to some defect in housing. Now, that's somebody who may have a high school education, is not really basing their opinion on any kind of schooled, or at least very little schooled expertise, but a considerable amount of actual expertise in terms of actually knowing how things are built, how they should be built, and how they can be defectively built. And so that person would be an expert witness. So again, you can see how a doctor can be a lay witness, and a contractor is just an ordinary guy, can be an expert witness, depending upon what they're testifying to and what's the underlying basis for their testimony. All right, so Federal Rule 702, if scientific, technical, or other specialized knowledge will assist the trier of fact, which means the jury or the judge, to understand the evidence or to determine a fact at issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify to an opinion on such issues. Okay, that's the authorization for the use of an expert witness at a trial. If it happens to be that scientific, technical, or other specialized knowledge will assist the jury to understand the evidence or to determine a fact and issue, a witness who's qualified in that particular area, either by knowledge, skill, experience, training, or education, can testify to an opinion on such issue. All right, you cannot be an expert witness to judge the credibility of a witness or for a legal opinion. Credibility of the witness is exclusively the province of the jury. They're the ones who decide whether they're going to believe a witness or not. And the judge is the sole opinion on the law. He or she will not be contradicted by any expert who comes up and says the law is really different than what the judge told you. We're not going to hear any experts coming on in front of a jury and contradicting the judge's determination on the law. That is exclusively the province of the judge. We will never see an expert on that. So if you want to know two areas where you cannot have an expert, it's an expert that talks about the credibility of witnesses, or one that offers an opinion on the law itself. This is what the law is in a given case. All right, if you're going to use expert opinion, the first thing you have to do, before you're even going to be allowed to present the opinion at all, it means you cannot even attempt to get the opinion out of this person until you have first laid a foundation that gives us several things, as we just talked about. We talked about just before, but we'll talk about them again. You first have to establish that the expert opinion must be helpful to the jury. That is very important. If you haven't done that, they're not going to allow your expert to testify because it's irrelevant or it's not helpful, and that's a waste of time. So we have to be sure that that's what we have, is that we have this this issue or this determination that the jury needs to make, and it happens to be that scientific or other kind of knowledge would be helpful to making that decision. Yeah, that's if we're in that area, then you can use an expert. Otherwise, you cannot. Number two, you have to set forth the qualification of the expert, and they must establish that their opinion, that means the expert's opinion, would be helpful to the jury. So you're going to have to find somebody out there who works in that area that knows that stuff, knows it very well, at least well enough, that they are better than the jury in terms of their knowledge of the subject. And, of course, as we said before, it has to be a subject that would benefit the jury to have this extra knowledge or expertise to interpret the evidence that's being presented. No formal education is required. It's very important for you to know that. You need sufficient expertise in the field to give a meaningful and useful opinion on some factual issue in the case, and that's about it. Okay. There's also 104A factors also. We'll get into those a little bit later. But for right now, all you need to know is that you can have expertise without having a tremendous amount of formal education. You could have no formal education at all, in fact, and have expertise in a certain area. And it's just because you happen to have that expertise that you developed on your own informally. All right, let's look at the basis of an expert witness's opinion. All expert opinions are based on reasons for that opinion. And what I'd like you to do is to actually go into your materials on the module and actually pick up this Zimmerman case. Remember, everyone knows what the Zimmerman case was. That was the case where the no back down law, I think it was in Florida, was litigated, where a guy ended up shooting a black man who he said had attacked him, and the question was whether or not he had to back away before he could use deadly force or not. And the law in that state said you don't have to. If you've been attacked, you can stand your ground and shoot the person. And so the question became is whether or not he was in such a position where he was in peril at that point that he could use that gun. This is a very good video. It's a YouTube video where the actual expert who testified in that case for the defense, who was a police officer, by the way, and an expert in the use of force, testified as to why he thought Zimmerman had the requisite requirements for using deadly force at that time. And it's sort of an eye-opener, but it's a very good way to show you an expert who's giving you the reasons why they have the opinion that this person had sufficient basis to use deadly force. So you'll see all sorts of reasons coming out, and they're well considered, and they are based on someone who you would expect would have knowledge of that area and know what they're talking about. All right, so what are some of the questions to ask an expert? First, detailed description of their educational background. That you want to, if it's important. It may not be, and if you have the contractor who has a high school education, we really don't care about that, but we'll continue on. How about a detailed description of their work experience? That may be very important to the contractor. It'll probably be important to most experts because even though they may be good academics, for instance, if they haven't worked in the area, they're not going to be considered a very good expert, generally speaking. Nice to have the academic background, but we really do respect the fact that people actually worked in the world and saw these things firsthand on their own before we really think that they're that good. Also, what about specialized skills that were used in their work? They may have some of those. Has the expert performed any research in his or her field? If they have, that means that they're on the cutting edge of their field. If you're on the cutting edge of your field, it gives you a pretty nice little bonus in terms of credibility because you're adding to your field. You're not just somebody who's in your field who's practicing. You're actually adding to the science of the field itself. Has the expert made any innovations in his or her field? Same thing. If you've made innovations, either through research or otherwise, that shows you're on that cutting edge of your field. Also, what about professional organizations that they belong to? Those can be important because sometimes it takes a certain amount of qualifications to even belong to them. And when they do belong to them, they're certainly skilled by being able to talk to a lot of other experts in the same field about lots of different stuff. How about positions of responsibility held in any of those organizations? Maybe they've been leaders in those areas, which means that they maybe have been recognized as a leader in their field, and that they want to be put in a position of leadership because of their recognition of the fact that they're a leader in the field. How about information about credentials that might be useful in establishing expertise to the jury? Perhaps there are certain government licenses or credentials that they have to have, and they do have. All right, has he or she ever testified as an expert before? It's kind of important. It's an important one because if they've been testifying as an expert before, that indicates that a court has already established them as an expert in that field. That is good credibility evidence. And sometimes you'll get experts who testify hundreds of times, which is kind of hard to do because you think how many trials are there out there. But sometimes that's all they do. People have made a career of just being an expert witness, and they can be very good at it. They command very high salaries in a lot of the areas. All right, has he or she ever provided guidance as an expert in any other matters where litigation was involved? And this is where they put as an expert, consultant expert in litigation rather than actually being an expert who testified, for instance. And then what, if anything, the opponent might use to discredit the expert testimony. So you want to bring that out too. It may be, for instance, that although they are very well known as an expert, they are an expert that has been called 99% of the time for the plaintiffs, only 1% of the time for the defense in a given kind of case. That would tend to indicate they might be biased as a possibility. And of course, after considering all these questions, the other side, of course, can ask all the other questions that would tend to bring out the bad parts about the expert, the things that are not quite so good. And they will do that if they have the information. They will bring those things out. Or maybe they just don't care because they're not really worried about the opinion for a lot of reasons. It may be that the opinion is based on something they said and it didn't happen. And they'll just bring that up. If something didn't happen, would you have a different opinion? They'll say, oh, yeah, of course. Okay, thank you very much. That's all we need to know. If we're going to establish the fact that something didn't happen that the expert says must happen for them to have the opinion that they have, then we're not really worried about their opinion so much. All right, expert opinion. Rule 703. Experts may use information that is reasonably relied on by experts in forming opinions, even if that information would not be admissible evidence in the trial. This is a godsend to attorneys. What it means is if you can use an expert, you can get in a lot of stuff you could never touch in a trial. You're not even allowed to touch it. Could be hearsay, what people have told you in the past, what your experience has been, what other people's experience has been as it was told to you as the expert, what they have read about other people's experience in books, that's hearsay again also. What the scuttlebutt is in certain areas, or what the rumors are, could potentially be something that an expert could testify to, but may never be able to be allowed into a trial under any other circumstances. Also, experts can use sources of information that are commonly used by experts, such as source material like books, standard books in engineering, for instance, will give you tables about how to calculate different things, and they can sometimes use telephone books or other sources of data or databases that they find to be reliable. That information could be part of their reasons. So they can go out and gather all the information they want from any source at all, so long as it's one that an expert in that field would typically use and rely upon as being truthful. They can use that evidence, whatever it may be. And I've had situations where I got in so much stuff into a trial, I just thought I should be ashamed of myself. I got in an asset forfeiture case the fact that the location where one of the defendants said he had a business was looked at by a different police department. They actually looked in the window of the business, and it was abandoned. The whole place had been abandoned. The guy said, "I have a business at this location." They sent another cop down there from another police department on the other side of the state to go look in the window and see if there was anything there. And he did, and there was nothing there. Well, that was told to my expert. My expert testified to that fact, which is total hearsay and totally inadmissible hearsay. But he used it as a basis for why he believed that the money that they found on this guy came from the sale of drugs. He was making up a story about where it came from, and that story was false. It didn't come from a business he had on the other side of the state. It came from somewhere else. So he was being false about where the money came from. That's a good sign that that it was money coming from drugs. Okay. All right. An expert can testify from a hypothetical situation presented to them in trial. So they don't have to go out and research everything themselves if you don't want to. And in very simple cases, we won't do that. What we'll do is we will give them the hypothetical before they come in and ask them what their opinion is, because we don't want them testifying, obviously, to something that, we don't ask them for an opinion before we know what their opinion is. We're not going to bring their opinion on if it's going to be against us, obviously, on either side. But we give them a hypothetical, and so this is what it'll be. This is typically what happens in a DUI case. This is a great example. Someone will testify that even though their blood alcohol came back at a 0.12, which is 1.5 times more than they're allowed to drive with, they said, no, it's impossible for that to be accurate because I only had 2 drinks. That's very typical. Every time the cops stop somebody and they have been drinking, they'll always say I had 2 beers. Every time, no matter what. And then they'll come in and they'll testify, well, it wasn't exactly 2 beers, it was actually 3 beers, but it was over 4.5 hours. Okay, so then I'll get the expert to come in. I'll say, okay, expert, I want you to assume that a man that was 175 pounds had 3 beers over 4.5 hours. That's a hypothetical situation. I want to give you that hypothetical situation. Now tell me, at the end of 3.5 hours, what would that person's blood alcohol be? And they'll come out and testify, 0.02. Oh, really? So it wouldn't be anything close to a 0.12, would it? No, it wouldn't. So how much would he have to have drunk in order to give him a 0.12? Well, 6 times that much. So not 3 beers, but maybe 18 beers over 3.5 hours? Yes. Oh, okay. Thank you very much. And maybe then he wasn't drinking beer. He was drinking hard stuff. You never know. Anyway, that's a typical hypothetical situation, which destroys the defense saying he only had 3 beers, because it's impossible for him to have gotten to a 0.12 on 3 beers. It's just not possible. He's not even in the range of where he should have been. based on what we know is the uptick and downtick of alcohol in the blood. When you take a drink, a 150-pound man, for instance, one drink will bring his blood alcohol up to a peak of 0.02, and it'll take an hour for it to be down to 0.00 again. So we know this stuff because they've actually done experiments with it. It's pretty clear. You can do the experiments all day and you'll find the same results. Anyway, so that's a good hypothetical situation. So you don't have to let them go out, an expert go out and actually gather all the information and then come to an opinion, which is a good way to do it, by the way. But you can just give them a hypothetical. If it's a very simple situation, you can do that, and that often happens that way. Okay. Expert's opinion on the ultimate issue. This is one that we talked about earlier as being a problem, and it is a problem. So we want to be sure to treat it very carefully. Okay. Now, the ultimate issue in a case, it's the issue upon which a finding must be made for the case to be decided. In essence, if you have a negligence case, the ultimate issue is whether they were negligent. If you have a case of driving under the influence, it's a question whether were they driving and were they under the influence. If it is a case of robbery, the ultimate issue is did they rob the person? Although you typically won't have an expert on a robbery case like that, not for the ultimate issue anyway. The rule is that an expert can testify to the ultimate issue in the case if it is helpful to the jury. If it is helpful to the jury. And in some cases, we have to do that so that you can testify to an opinion of negligence, to legal insanity. So, for instance, sometimes we go into criminal cases and the defense says, well, we want to defend this case on the basis that our client was legally insane at the time of the trial or at the time of the crime. It happens to be that the law says if you were insane at the time of the crime, you're not responsible for your criminal act. So they have to be put in a mental hospital, but they're not put in prison. Well, then the issue in the mini trial we have before the case opens up on the issue of legal sanity is whether they are legally insane right now. Now, you could bring in experts and they could testify, yes, I think he was legally insane, both at the time of the crime and now. And that's the ultimate issue. So you can do it, but only if it is helpful to the jury. It is not always. So, for instance, you would not have an expert coming in and testifying that, yeah, a certain person robbed another person. That's not something where expert witness or expert opinion can ever be helpful. There's no way for an expert to be able to judge what happened better than a jury, and so it's never going to be helpful to a jury, ever. It's only when scientific knowledge will help that culminates in that opinion will help on that ultimate issue before we're going to allow it to be used on the ultimate issue. All right, expert opinion. The expert must use the legal standard for their opinion on the ultimate issue if they're going to testify to the ultimate issue. They actually have to state to the jury what their legal standard is, and it has to be that same standard that will be applied in that case, or the judge will not allow the expert opinion because it's basing it on a different legal standard. If there is a legal standard, the legal standard is negligence, for instance. There's a legal standard for negligence. There's a legal standard for legal insanity, and so on. All right, the expert must use negligence law to testify on an opinion of who was negligent in a court case. For example, an expert must use the applicable mental defense elements of insanity to testify as to whether a criminal defendant was legally insane at the time of the murder. That would be the McNaughton test in California, which we don't have to get into what the McNaughton test is, but that is a test that is used in California, it's used in most jurisdictions, including federal courts as well. It's been around for several hundred years, and it's a pretty good test. It's been literally tested over many hundreds of years in both the English and American legal systems, and that is the test that has to be used by them if they're going to talk about legal sanity or insanity. All right, Federal Rule 704B has an exception. An expert cannot testify whether the defendant had or did not have the mental state constituting an element of the crime. So, if murder requires a specific intent to kill, the expert cannot testify that this particular person actually had that mental state or not, because that's the province only of the jury. Only the jury can decide that. They can testify, by the way, as to whether he had the ability to form that intent or not. Meaning, did he have sufficient legal sanity to know what he was doing and knowing that it was wrong at the time he was doing it? That they can, but they can't actually testify that he either had or didn't have the mental state of specific intent to kill when they did their the action that ended up killing someone. Okay, so that's important. That's a exception to this idea of the ultimate issue. You can't have them testifying to mental states of people, what their actual mental state was. That's only for the jury, and that's because scientific evidence cannot tell you what the actual mental state of a person was. That's something only the jury can decide based on what the evidence is that's presented. Now let's look at court-appointed experts. Now, courts have the discretion to say to the parties in a case, they're going to go at each other with experts, you know what, I've had enough of these biased experts. You're both going to go out and hire your own hired guns, and both are going to come to the opposite opinion, and they're both going to be biased. And this is much too important. It's going to waste a lot of time in the courts. It's going to waste a lot of money for the litigants. I'm not going to allow you to have your own expert. Instead, I'm going to appoint a court expert who is going to be paid by the court, but the parties are going to pay the court for them, but who is beholden to the court for coming to their opinion, and is going to be unbiased. And they could do that on their own motion. They don't even have to ask. The parties don't have to bring a motion to have this done. The court can say, no, I see this case coming. I'm not going to allow this to happen. And it could also be at the request of either or both parties. One party might come and say, hey, judge, you know what? I want you to appoint experts. I know what's going to happen. We're all going to hire our own hired guns. We're going to pay $20,000 a piece for them. And you're not going to be very convinced about having two biased expert witnesses in here. I think you'd be very, very convinced if one of your court-appointed experts were to give you a certain opinion, but not two biased experts. So let's appoint it. And you may ask the court to do it, but you don't have to, because the court can do it on their own. In this case, the expert will be paid by the court, but the parties have to pay the court for the expert. And it's hoped the expert will be more objective than the expert for the parties, because they're being paid by the court, they're hired by the court, they are beholden to the court for their work, and they're not an advocate for any party. So it does usually work very well to keep them in an unbiased state. And they know that they're going to be shot down by both sides. And so they usually do a much better job also in coming with their reasons, and make sure that they're pretty much bulletproof reasons, because they're going to be shot at by both sides. And so they know that. All right, that's it for lay and expert witnesses. These are important rules for you to know, and they shouldn't be too difficult to understand. Do go by that video that I asked you to look at, because I think it will help you a lot to see how experts give their reasons for their expert opinion. Gives you a flavor for what this is all about. All right, again, if you have any questions, please feel free to give me a call.